Hi, this is Tyler Danzel, and this is Module 8, Legal Aspects of Teacher Evaluation for EDL 851. So a little overview of teacher evaluation. This issue has become very contentious in the past few years. However, despite all the attention and all the changes that have been made, there's a lot of teachers that just continue to score the same as they once did. So a lot of people wonder if this is even an issue that really needs to receive all that attention. Over the past few years, many states rewrote their evaluation laws because of the prospect of some large grants that were out there related to changing evaluation. And also some states, unfortunately, started connecting evaluation to bonuses and tenure and dismissal and things of that nature. So the new evaluation systems are a lot more complex, and many include student test scores as a large part of the evaluation process. There was even an article, however, by the U.S. Department of Education that said some of this student test score portion of the evaluations could be subject to random error. Teachers' unions obviously had a strong response to this. The NEA kind of took the high road at one point and said they welcomed the chance to promote the advancement of the profession and make changes to improve the profession. However, they don't support connecting evaluations to pay and tenure. One of the obvious things that got pointed out was that teachers work with different populations of students that have varying levels of achievement, and it's hard to evaluate all teachers on the same plane because of that. The Every Student Succeeds Act, it does not require states to create evaluation systems that are significantly based on student test scores, so this is a good thing that has come up recently. States get to redesign and submit their new evaluation systems to the U.S. Department of Education. Some of the key provisions of ESSA, it prevents the Secretary of Education from really meddling in a state's educational system. States get to set their own goals and decide how they're going to gauge school effectiveness. And they can design evaluation systems that are based on multiple measures of teacher effectiveness and student achievement. Some of the bargaining and advocacy implications. ESSA contains provisions that are rights-preserving rather than rights-creating, meaning if a certain right was already in place, it remains in place, but new rights or clauses cannot be implemented. Some other points to consider about ESSA. The local association should try to negotiate evaluation standards when possible, and in places where negotiations are not allowed, teachers should try to be involved in the evaluation development process. These new systems, they need to be piloted before they are tied to any high-stakes evaluations, and improvement plans and due process rights, they should be aligned with the due process rights that are already in the teacher contract. Some noteworthy court cases. So I won't go into a lot of details, but many of these court cases that were laid out in the article for this particular section, many of them are related to the same thing. So we're talking about due process rights, we're talking about tying teacher evaluations to merit pay, or using a school-wide data formula to evaluate teachers who didn't even teach those students or don't teach those particular subjects. So that's where the Florida cases fell into. Also Louisiana, where state law was created to tie wages and tenure to teacher evaluations. In Nevada, state law allowed tenured teachers to be fired without due process following 2 consecutive ineffective evaluations. In New Mexico, some teachers felt they received poor evaluations because of flawed data or was linked to the wrong students. And also in New Mexico, there were 2 suits that argued that the evaluation system that was imposed by the State Department was not legal. In New York, there were 2 suits that said the state didn't fully take into account poverty levels when creating their student growth formula. In Tennessee, again, missing out on bonus pay because of test score portion of evaluation. And Also in Tennessee, there was an argument about using a school-wide growth measure. The court case I really like to focus on, and is actually still ongoing, is something that took place in Houston, Texas. The Houston Federation of Teachers, they argued about the use of the student growth numbers. They said that the standards were vague, the method was opaque, and teachers who worked with vulnerable students were at risk for receiving poor evaluations due to lower test scores. This trial began in June of 2016, and just this past May, a judge, while he dismissed several of the claims in the lawsuit, he did not dismiss the teacher's procedural due process claims, and that helped advance the case. In the school district I work in, Derby USD 260, the certified evaluation process goes like this. In the first 2 years, all teachers will be evaluated twice annually. In years 3 and 4, all those teachers that fall into that category will be evaluated once annually. And after year 4, there'll be formal evaluations every 3 years. And on those off years, the evaluations will be informal. So if there is a grievance, the teacher's procedure is laid out in the master contract. Level 1 would be just to simply meet with the principal or supervisor. Level 2 would the teacher would make a formal filing with DNEA, which is our local teacher association, and also the principal supervisor. Level 3, again, file with the DNEA and then meet with the superintendent. Level 4, there would be grievance mediation. Level 5 would be a hearing with the school board in executive session. And level 6 would be arbitration. And at all levels of this grievance procedure, the teacher can be represented by someone appointed by DNEA. So some final reflections by me. A lot of this stuff really appears to be common sense. I just feel like if a principal uses common sense during the evaluation process, and when there are issues with the teacher evaluation, a lot of problems can be averted. I also think it's pretty obvious that a principal would need to make sure they are following Board of Education policy. And then finally, when in doubt, collaborate with the superintendent and also, if needed, district legal counsel. Thank you for viewing my presentation.